contribution limits are a bad idea, but we have to be really careful about how we do it. And this initiative illegally discriminates between people who speak. The problem with campaign contributions is you can't kind of put your finger on the scale and say we're going to let some people speak and not other people. So an across-the-board limit that treats everybody fairly makes sense to me, and it makes sense to the courts. But I think there are some things in this initiative that are going to be a pretty serious problem after the election.
All right.
If the people vote for it.
We'll get to that in a second. But in the way the signatures were gathered, in the way they were handed in the way it's on the ballot, do you have any problem with that?
In the way the signatures were gathered and handed in, no. Now, in the way it's on the ballot, yes. This is a 9 legal pages long constitutional amendment. And there's a ton of moving parts in this thing. And that's the issue. It doesn't read like what we think of as a constitutional amendment, a short statement of rights or principles. This is a very long scheme that was basically written by one person. And there are mistakes in it, and it should not be on the ballot because of those mistakes.
All right, so what are the issues that you don't like about this initiative?
Well, the lawsuit that we filed was on behalf of the Missouri Rural Electric Cooperatives, and I think that's the classic example. The initiative says that the Missouri Electric Cooperatives must stop contributing to their own political action committee. They're not allowed to give anything. Yet at the same time, Ameren and Kansas City Power and Light and all of the big investor-owned utilities are allowed to use their corporate money to contribute to campaigns. That's a problem. Same's true of banks. Banks are not allowed anymore to contribute to PACs under this provision. But they allow all kinds of other companies, credit card companies, prepaid card companies, to contribute to PACs. I just don't think it was drafted very well, which is really, I think, a problem when you allow well, it's something we got to be aware of when we look at initiatives. It doesn't go through a legislative process that works out the difficulties. I mean, anybody with enough money can sit down and draft an initiative and get it on the ballot.
Well, that's another issue for another day. And while certainly people can agree with you, and if you had a legislature that was actually functioning and actually took up issues, but this is to circumvent the legislature because a citizen doesn't feel that the law they passed is beneficial to the citizens and beneficial only to them. So this is a way to sort of check the legislature that many people feel isn't functioning correctly.
Well, that's right, and that's the reason we have an initiative petition process, is to allow the people to bypass the legislature if they feel like government's sort of gone off the rails. But it's a pretty awesome power. I mean, I find it really ironic. Your intro was perfect. I find it really ironic that a person, one individual, has spent probably millions of dollars to try to keep people from spending probably millions of dollars.
Well, that, again, another topic for another day. But in this legislation, in this constitutional amendment, does it say specifically that this rural co-op is not allowed to give, but farmers are allowed to give? I mean, is it broken down that specifically?
Yes, it says that political action committees can only accept contributions from corporations that are formed under certain chapters. And personally, I believe it's a drafting error. Now, the people who drafted it have never admitted that, but I think they just made a mistake. And they've said you can only contribute to PACs if you're formed under certain chapters in the statutes, and they list them by number, which is very unusual in a constitutional amendment. And electric co-ops cannot be formed under those chapters, but, for example, Ameren UE is formed under those chapters. I think they made a mistake, which is kind of my point about, having these really long, detailed, specific things in the Constitution. If there's a mistake, it's really hard to undo it in the Constitution.
Yeah, Chuck, are you the courts ruled that the ballot initiative is fine, the signatures are fine if it is passed by the people and becomes a constitutional amendment, then you can challenge it for all sorts of reasons.
That's right. That's right.
So, okay, now the next question is and this is maybe there's a question for Greg Willard, our legal analyst from SLU University, but a state constitutional amendment can be unconstitutional.
Correct.
But a U.S. constitutional amendment can't be unconstitutional.
Right. So I'm going to answer the first question. The Missouri Constitution cannot conflict with the federal Constitution. Interestingly enough, McGraw, the Missouri Constitution actually says that there's a section of the Missouri Constitution that says nothing in this Constitution shall be, quote, repugnant to the U.S. Constitution. So that one's pretty easy. I assume that a federal constitutional amendment, by definition, could not violate the federal Constitution.
Right. I mean,
I've never heard of such a thing.
Right. There was a constitution that said nobody was allowed to sell beer. Now, today, that would be thrown out for all sorts of reasons, but it was a constitutional amendment, and it wasn't unconstitutional. So it passed, and it was what it was, and then it was repealed. But anyway, Chuck, I'm going to ask you this. Are you really against campaign limits, or are you for campaign limits and just against this quote-unquote poorly worded amendment? Or is this a way for you to sort of keep the limits unregulated?
Well, personally, I'm for campaign limits, and I think most of my clients in this particular case support some sort of campaign limits. It's tricky business, and it has to be done right so that we don't cause unintended consequences. Generally, I think limits are a good idea.
Who are your clients? Who are you working for? Are you doing this on your own, or are you being paid by somebody to do this?
We were being compensated. So our clients were the Missouri Electric Co-ops, a bank called Legends Bank, which had sued before over a very similar provision and won years ago. David Klent, who is a citizen, former state senator who is active in the electric co-ops. So those were our clients.
Yeah, but it seems like, and as you said, as you point out, you think these are just drafting errors because of sloppy workmanship.
I do. Yeah, I think that's right. I don't have any problem personally with Mr. Sauer's desire to limit campaign contributions. We could have a whole nother show about what the issues are with that. I generally think it's a good idea. People can find ways around the limits, but if you want to give hundreds of thousands of dollars to a candidate, it ought to be really hard.
Yeah, well, if that's the case, then why can't these banks and these co-ops and these people that are not allowed to set up some other type of fund and allowed to then contribute that way?
Well, that's one possibility. The courts have said, the U.S. Supreme Court has said that they shouldn't have to do that that's too much of a burden to have to go create these other systems to basically get around the regulation. But yeah, that's a possibility. I mean, I think that if it passes, there will be some attempts to deal with it, but I also think it's going to face some lawsuits, either from my clients or others.
Chuck Hatfield, Jefferson City Attorney, who is talking about the problems with the campaign contribution ballot initiative. What number or what letter is that going to be on the ballot in the fall?
Oh, gosh. That is Constitutional Amendment number 2.
Number 2. All right, good to know. Chuck Hatfield, thanks for checking in, and hopefully we'll talk to you between now and Election Day.
Thanks, McGraw.
You got it. Chuck Hatfield here on the Big 550 KT.